My name is Jessica. My family and I are victims of domestic violence. My ex-husband was our first abuser, and then we were further victimized by the Superior Court of California in Siskiyou County, the Siskiyou County District Attorney's Office, the Siskiyou County Sheriff's Department, as well as other police agencies in Northern California. From the time I was 17, my ex-husband, David Murr, had been grooming me to be his victim. By the time I was 20, we were married, and his physical abuse of me and his control over me and every aspect of my life was nearly unquestionable. I called for police assistance on numerous occasions during our marriage, and the few times that police even responded, they never arrested him, never told him that what he was doing to me was a crime, and never told me that I had any other options or resources for help. When I was 25, I had my first child, our daughter, who is now 8, and before she was a year and a half, he had begun neglecting and physically abusing her. My maternal instinct told me that I could not let that continue. I told him I wanted a divorce, and again, he physically attacked me. He restrained me, hit me, threw things at me, and told me he would kill me. I sought a domestic violence restraining order, and the temporary orders were granted. He almost immediately violated them when he showed up in the middle of the night and tried to kidnap our daughter from her bedroom window. Even then, when I called sheriff's deputies, they didn't respond to the house. They called him and he admitted to them that he had been there, but they never came and they never arrested him. Weeks later, they mailed him notification that he was going to be brought up on charges by the district attorney's office, and the following year, he pled guilty to violating the domestic violence protection order, although he still was never arrested and never taken into custody. Part of his criminal charge was a criminal protective order that the district attorney extended for 5 years. It did not allow for any contact between us at all. I still had to move from Siskiyou County because he was violating it repeatedly. I caught him outside of my house, parked at the end of a rural dirt road, staring at me through the house windows. He called me and threatened me. He sent me threatening and harassing text messages on more than one occasion. Every time I called, Siskiyou County Sheriff's Office declined to respond at all. They didn't come to the house. They didn't take a report. I was lucky the few times they took incident reports, which were of course never forwarded to the district attorney's office. When I had to leave the county, I moved about 70 miles away to the next county where I had grown up. I had friends and family and support. My daughter and I tried to establish a new sense of security and normal, but it didn't take long for him to stalk me to my work and then follow me home. In 2015, the California Crime Victim Compensation Bureau approved us for relocation benefits as well as other assistance, and we moved out of state in fear of our lives. Of all the times that we had called police, they never, ever arrested him. Even when California Highway Patrol intercepted him following me after he had stalked me after court for a number of hours, the Siskiyou County Sheriff's Department showed up on the scene and told CHP to let him go, and they did. He came to my house in Shasta County, beating on the doors and windows. I called the Shasta County Sheriff's Office. They responded, they reviewed the protection order. They told me they were going to go arrest him for violation of the protection order. Then they called Siskiyou County to verify the protection order because the district attorney in Siskiyou County had never registered it in the national database. And the Siskiyou County Sheriff's Department told them not to enforce it, so they let him go again. When we were relocated with assistance from the state, we went to a different state. We went as far as we could go where we knew we would still have support and help, because by this time I realized that that was what I absolutely had to have in order to not fall back into a pattern of being a victim. Our new home state, when the criminal protective order from California was due for expiration, issued new domestic violence protection orders. The judge found that he had continued to violate the criminal protective orders. The new judge found that he had achieved custody orders out of California without my knowledge by stealing my mail and having my mail forwarded from my P.O. box to his own. They found that not only did I need protection from him, but that so did my children. They were 3 and 7 at the time. They took emergency jurisdiction over the custody issues, and I hired a new attorney in California to file a UCCJEA motion, which has to do with child custody jurisdiction between states. The judge in Siskiyou County that had granted him sole custody in 2015 without me ever knowing and without him ever attempting to legally enforce the order, denied my motion to have jurisdiction transferred to our new home state, even though every subsection of the UCCJEA, as California adopted it, indicated that jurisdiction should transfer. The same judge in the same ruling in 2018 gave our abuser sole custody of our daughter. She didn't even know him. She's never lived with him. She's only ever lived with me, except for the first year that he and I lived together before I asked for a divorce and had to file for the restraining order. The only interaction that she's had with him that she has any recollection of is when he's been violating protection orders and harassing, threatening, and stalking us. She was diagnosed with post-traumatic stress disorder, and I had been seeking trauma therapy for her. She had been receiving it in our new home state, and her counselors even wrote letters to the court in Siskiyou County and indicated to the court that her home was safe and happy and healthy and supportive, and that I was doing everything that a parent could do to encourage her to resolve her PTSD symptoms, and that any reunification with her biological father should be in short increments at her comfort level. Despite all this, despite the warrant that was active for his arrest and in the new jurisdiction for over 9 months, and it was active at the time that the judge made this ruling in 2018, despite the existence of the protection orders, despite the judicial findings that he had recently committed domestic violence against us, Judge Laura Masanaga in Siskiyou County, California, granted him sole custody again in 2018. Luckily, I had been tapping as many resources as I could find. I'd been in communication with multiple domestic violence organizations across the country, and someone put me in touch with DV Leap, which is based in Washington, D.C. They helped me find and helped even fund an appeals attorney who immediately filed an appeal of the Siskiyou County judge's order, not only for jurisdiction, but for the custody order. That appeal, as I record this video, is about 5 months in, but it's still a few months off from being complete. Still, even though he had an order for custody, he didn't try to enforce it. He didn't legally try to enforce it. He used social media and the internet to continue to incite violence against me and encouraged people to hunt us down, to tell him where we were, to do all the things that the protection order said that he couldn't do. He shared my picture, my new husband's photograph, encouraged people to hunt him and I, gave our names, our phone numbers out to strangers all over the internet. Another judge in the new jurisdiction, when I applied for a modification of the restraining order, told him that what he was doing was wrong and that it was putting our little girl in danger and that there was no excuse for his behavior. She said that there are legal ways to enforce custody orders. This is not the way to do it. But he was not deterred. So the prosecuting attorney in that jurisdiction brought charges against him. That was how he ended up with the warrant that was active for his arrest for 9 months in 2018. And that's the warrant that was active when Judge Masanaga granted him custody orders. California Family Code Section 3044 is in regards to child custody in a situation where domestic violence is presumed to have occurred. And from what I've been told and what I've read on case law and the family code sections that accompany 3044. A person who is presumed to have committed domestic violence should not have custody of a child. Not legal custody, not physical custody, not even joint custody, because the state legislature has determined that it is not in the best interest of a child to be exposed to domestic violence. Case law indicates that the issuance of these out-of-state protection orders should have automatically triggered the presumption of domestic violence. The judicial finding that domestic violence had occurred should have also triggered the presumption that domestic violence had occurred. The criminal charges against him and the warrant for his arrest for domestic violence, again, should have triggered the presumption of domestic violence under Family Code Section 3044. And Judge Laura Monsinaga ignored all of that. At the end of 2018, I filed to renew my restraining order that was issued out of our new home state. And it wasn't until that time that he made an effort to legally enforce the custody order that he had had for the majority of 3 years by this point. Even though the judicial officer that found that domestic violence had occurred also found that he achieved that custody order by fraud, there was nothing that our new home state could do to stop him. My daughter's therapist called Child Protective Services to try to prevent him from taking her, because it was well documented and well established that he was the cause of her post-traumatic stress disorder. But still, he took her. He's had her for 3.5 weeks. He took her from her home, from her parents, from her brother, from her grandmother, from her school, from her neighborhood, from her friends, from the little girl next door that she's grown up next door to, her best friend. He took her from music lessons, he took her from therapy, he took her from her local ice skating rink, he took her from her cross-country team. He took her from a beautiful life where she was thriving and she was happy, and where her therapist said that she would eventually overcome all the symptoms of her PTSD. And he has isolated her in Siskiyou County, California, where she is not receiving trauma counseling, where she has been repeatedly asking to talk to me and to call me, and he's been refusing to let her. When I called the Siskiyou County Sheriff's Office and asked them to do a welfare check on her, they went to his house, they found him. They didn't find my daughter. When they called me and told me that they couldn't find her and she wasn't there, I asked if they were going to do any further follow-up, and they said no. I had to call a state representative's office, the congressman's office, and go to the county board of supervisors meeting before somebody finally did a welfare check on my daughter another week later. My daughter now reports that school is horrible, which is not my little girl. She loved school. She loved to be in the classroom so much that she chose to have her therapy during recess because she didn't want to miss any class time with her friends and her teacher. On January 22nd, I appeared personally in Siskiyou County Court. The week earlier, I had filed paperwork on an emergency basis using legislative law to request that custody be returned to me under the Family Code Section 3044, because a new restraining order had been issued from my new home state against my ex-husband. The first judge that reviewed it had recused herself a few years earlier and was not supposed to be viewing anything to do with my case. She denied my request. When I called the clerk and alerted them, they agreed that I was right, that that judge was not supposed to review my case. They gave it to the presiding Judge Robert Davis. He rubber stamped the exact same thing that the recused judge had written on the orders. So I filed again, hoping to be in front of Judge Davis and explain to him the necessity and the emergency that these orders be granted. Instead, I was calendared in front of Judge John Lawrence. When Judge John Lawrence was a private practice attorney, he represented a third party in a civil suit against me, and in a separate matter, represented a third party in a civil suit against my ex-husband. If he were still in private practice and I wanted to retain him for representation, it would be a conflict of interest and he would not be able to represent me. However, he ruled that that didn't matter and the conflict was not something to be considered when reviewing my case as a judge. He refused to let me present my case. He did not swear me in. There are no records of anything that's happened in my case in Siskiyou County because Siskiyou County does not make records of what's going on in their proceedings. And if they catch someone a litigant in the courtroom trying to make their own record, they will remove you from the courtroom. In addition to representing a third party when he was in private practice, I also had to file a police report against John Lawrence when he physically assaulted me in front of my place of business when the civil case that he was representing this person in against me didn't go the way he wanted. There is a police report on file with the Wairika Police Department. The Family Code section that I read after this date says that if any person should have a reasonable doubt that a judge is unable to remain impartial, that judge shall be disqualified from hearing the case. I'm pretty sure having to file a police report against someone for assault and that person having represented a third party in other civil cases against a litigant meets that burden. On January 24th, I was back in court in our new home state for the new protection order against my ex-husband. This time it would protect me, my husband, my new husband, and our 4-year-old son. I was unable to put my daughter on it because California had refused to acquiesce jurisdiction over custody of her. Those orders were granted, and during the course of that hearing, my ex-husband admitted that my daughter had been requesting to speak with me on the phone and that he was not letting her. So the judge in our new jurisdiction allowed for an exception in the restraining order for telephone contact so that my daughter could call me. She still has not called me. It's been a week. I've called his phone number and he rejects my calls every time and it goes to voicemail. So I'm unable to reach her. On January 28th, I appeared in person in Siskiyou County in court again. And again, it was scheduled in front of John Lawrence. And again, he refused to let me present my case. He refused to let me speak almost at all. His first words when he called the case was, "Let me tell you how this is gonna go. I'm denying your request." He said that all my facts and support were identical to my first filing, which they were not. My first filing referenced legislative law. This filing referenced case law, both upon which dictated that my daughter should not be placed with an abuser and that I requested that she be placed back home with me. My ex-husband was not supposed to know that I was even in California, let alone that I was going to be at the courthouse that day. There was no one else in the courtroom. There was no other docket scheduled for that time, and I was the only name on the docket. He followed me into the courtroom, and when I alerted the bailiffs that there was a domestic violence protection order in place and that he was violating it, they made excuses for him, indicating that he seemed to have other business to be handling in the courthouse. My husband and I went into the courtroom. He followed us in there. As soon as Judge Lawrence was done denying me the right to have a hearing, my ex-husband fled the building. He had no other business in the courthouse that day. He was there solely to intimidate and scare me, which he did. We learned when he passed through the metal detector when he came in that he has a third set of criminal charges against him. He's wearing an ankle monitor. I don't know much about these things because I don't have a criminal record, but I understand that they are typically ordered only when a person is on house arrest or probation, and not typically for misdemeanors or minor offenses. I believe that to be true because this county is very economically disadvantaged. They say over and over, they simply don't have the resources to do a lot of the things that are expected of them. So in order to put an ankle monitor on a person, it had to be a pretty bad criminal charge. I went to the probation department to try to find out under the Public Information Act what his charges might be. They told me their blanket policy is they don't provide information about anyone to anyone. I tried to get the contact information and the badge numbers and the names of the bailiffs that saw him there that day and that refused to enforce the protection order. And all 3 bailiffs refused to give me their badge numbers. I was able to get the sergeant's name, and he spelled it for me and gave me a phone number, and 1 other bailiff was wearing a name tag, so I got his first initial and his last name. I'm informed that law enforcement is required to provide their badge numbers when you ask for them. But in Siskiyou County, they don't do things according to the law, they do things according to the way they feel like doing them. Another example of this is that the Family Code section requires that family court services have annual training in domestic violence. When I inquired about training records at the Siskiyou County Family Court Services desk, I was told that no one has ever had any domestic violence training at all. There are no records. I asked for a copy of their written domestic violence policy, which they are required by Family Code to have, and they don't. They've never had one. On January 29th, I submitted a written request to the court executive officer for domestic violence training records for anything that might be on file for any of the judges that are currently sitting or for Judge Laura Masanaga, who's now retired. I also requested copies of any domestic violence training received by any of the staff and supervisors in Family Court Services, and I quoted the Family Code section that requires that training. I also filed a letter with the court executive officer indicating that Judge John Lawrence had a conflict of interest that should have disqualified him from presiding over any case to which I'm a party. I have not heard back from that. I will post another video if I do, and I will disclose whatever she tells me. On January 28th, after Judge Lawrence decided he was not going to allow me to have a hearing or hear any motion that I had to file, I filed a motion for reconsideration for Judge Davis's denial of my request for emergency orders. That hearing was scheduled for January 30th, and on the morning of January 30th, I received a call from the court clerk informing me that the night before, after 5 o'clock, Judge Davis had vacated my court date and denied my request for reconsideration. No reason was given. I have not researched the family code on this, but I don't know that he can refuse to let me have a hearing. So I would appreciate if any knowledgeable experts out there, preferably licensed and well qualified, have a family code section that they could refer me to on this. I reached out to my congressman's office, the Board of Supervisors in Siskiyou County. I've reached out to the state representatives. I have done literally everything a person could do. I have taken all the steps a victim can take in order to seek protection under the law. Anytime these efforts have been made in California, particularly in Siskiyou County, they've been fruitless. It wasn't until I left California that I learned that law enforcement in other places does enforce the law, and that in other places, a protection order does mean something, and it's not just a piece of paper. I learned that other prosecuting attorneys will do their jobs and will help the victims and will represent the state when a person breaks the laws of that state. I still have yet to see any indication that any of those things happens in Northern California. My little girl is still suffering, and we're not the only ones. The broad policies that Siskiyou County has adopted to reject the existence of domestic violence and domestic violence as a legal thing have affected hundreds, if not thousands of people. They didn't not have training in domestic violence in the Family Court Services Department for all these years in an effort just to spite me. They aren't breaking the California Information Act rules just to spite me. This is just how they do things in Siskiyou County. I need you to share this video with everyone you know. If you know legislators, if you know reporters, if you know senators, congressmen, lawyers, judges, tell them what's happening in Siskiyou County. Tell them about the abuses that victims are being subjected to even after their physical abusers are done with them. Tell them about how families are having to flee their homes and leave behind their friends and their neighbors and their family and their jobs because law enforcement and the district attorney and the judicial system will not enforce the laws that were intended to protect them. Tell everyone, because I have told everyone I could get to listen, and there doesn't seem to be any accountability. I have filed complaints with the Commission on Judicial Performance. I have sent letters to the Judicial Council of California. I've spoken with dozens of domestic violence agencies and child protective agencies and lawyers, and everyone either tells me we don't provide direct services, or we don't work in Siskiyou County, or that's not our job to enforce the law. This has been going on for so long. And it's been happening a long time before it started happening to us. But it has to stop. Enough people have to become aware of what's going on that someone can shine a light on this, and someone can do something to interrupt it, and someone can start protecting victims. All the legislators that are working so hard, and all the lobbyists and all the nonprofit organizations that are going to so much trouble to pass new laws, it doesn't mean anything to victims if there's no one to enforce them. We need somebody to do something now. It's gone on too long. Please share this video and any other videos I've posted. Share it on Facebook, share it on Twitter, share it on your own personal website, email it to people, do whatever you can to let people know what's happening. Flood these little tiny mountain towns with reporters. Get people in here asking questions. Get people in here that can enforce these laws. Because my little girl needs it, and I need it, and my son and my husband need it, and our friends and family and all the people we had to leave behind all need it. We need your help. Don't let this continue. It's discrimination against victims. It's discrimination against vulnerable people. And those are the ones that these laws are supposed to be protecting. Please share this as many times as you can. Do it any way that you can and tell everyone, because it's not okay.